Welcome to this series of online tutorials. This series, Expert Witness Training, comprises 3 tutorials: the Australian legal system and an introduction to evidence, writing the report, and giving evidence in court. Before we launch into the substance of the tutorials, there are a few foundational concepts we need to discuss. In every workplace, in every life situation, there are individuals working together and living together with quite different roles. Think about a hospital. Within a hospital, there are a number of professionals working together. The aim of their work is the same, to care for the patients, but their roles are quite different. Think about architects and engineers. They're both involved in construction, but their roles are quite different. And so it is with experts and legal practitioners. We have very different roles and see things from different perspectives. Have a look at this image. What do you see? Some people will see a young woman looking into the distance. Some people will see an old woman looking towards the bottom left of the image. In this image, do you see a duck or a rabbit or a hare? Is this a 9 or is this a 6? My point is there are differing ways in which the same information can be used or explained. Let's take this concept a little bit further. Let's think about football first. There are a number of different codes within football: soccer, rugby league, rugby union, AFL. But the basis of the game is the same. There are 2 teams with equal numbers of players on the field. They move the ball from one end of the field to the other, and they score by getting that ball between some posts. The posts can have a net behind them or a bar across. Let's think about another team game, which is also a ball game. Let's think about cricket. Again, there are many types of cricket, whether these be test or limited overs, 2020. But in these codes, there are certain similarities, underlying principles. There are 2 teams. One has 2 players on the field, the other has 11. And the aim is to hit a bowled ball using a wooden bat, protect the wicket, and score by running between the wickets at each end of the pitch. However, football and cricket are quite different. Neither is right or wrong, they're just different. And so it is when we think about legal practitioners and experts. We think about things in a different way. But neither of us are right, neither of us are wrong. We're just different. And this can lead to misunderstandings as we understand things from different perspectives. Over the years, I've developed my own understanding of the law. The law is a set of rules which govern a society. Every person has an innate sense of right and wrong, but my sense of right and wrong may not be the same as yours. Our senses of right and wrong are developed from our cultural backgrounds, our life experiences, etc. Therefore, within a society, there needs to be a set of rules or laws developed which captures the social norm. And it is against this set of rules or laws that people's actions are assessed. Therefore, legal proceedings can be seen as an assessment against a set of rules, not an assessment of absolute right and wrong. Within the legal context, one example of this that I'm sure you're all familiar with is the chain of custody, sometimes known as the chain of evidence or the continuity of evidence. And as we all know, a chain is only as strong as the weakest link. On the right-hand side of the screen, I've transcribed a quote from a publication known as Expert Evidence by Freckleton and Selby. For scientists' evidence to be admissible, it must be relevant to the facts in issue. A short aside here, this quote relates to scientific evidence, but it actually is relevant to all expert evidence, not just that of the strict sciences. For scientists' evidence to be admissible, it must be relevant to the facts in issue. If a scientist gives opinion evidence which is based on the assumption that an exhibit tested was the same exhibit as the one seized or found in a particular place, that evidence ceases to hold any significant probative value if it's shown that the assumption is invalid. This just doesn't hold for an item, it holds for information, it holds for any derivative of the item, it holds for any potential transcription errors, and it holds for any potential tampering or contamination of the item. This is a rule that has been accepted by the courts. A breakdown in this rule can mean that evidence is deemed inadmissible and therefore cannot be used within the trial. No matter how good that evidence is, no matter how careful the analysis was, that evidence can't be used if this rule has been broken. The second foundational concept I'd like to discuss is the investigative and the legal process. This is divided into a number of phases. There is the initial investigation or examination. There is the case preparation phase where reports are written. And then there is the court proceedings. Matters may or may not result in a court proceeding, but it is always better to assume that they will and prepare accordingly. There is a fourth, not so obvious phase. This is the admissibility phase. All evidence must pass through the admissibility barrier to be able to be used in court proceedings. As I mentioned before, this means that no matter how good or how thorough our work is, if it cannot be accepted as admissible by the court, it will not be considered. In this context, we can see that the court process, and specifically the admissibility barrier, dictate, to a large part, how our work must be undertaken. The next step, once the evidence has been deemed admissible, is the weight that that evidence is given, the proof that is required. In a criminal matter, this is beyond reasonable doubt, and in a civil matter, on the balance of probabilities. These concepts will be discussed in subsequent tutes. For this reason, I don't think of the investigative or legal process as a linear process. I understand it as three overlapping domains. I believe that if we understand the forensic process, the investigative legal process, as three overlapping domains, we can see how each influences the other, and how each domain is equally important. You are probably undertaking these tutorials because you have an interest in expert evidence and the provision of expert evidence in court. And you may be wondering why there is so much focus on the legal system and legal questions. The reason for this is that the actual giving of expert evidence, or the writing of the report prior to the giving of expert evidence, is actually only the tip of the iceberg. It's the visible bit. It's the bit that we're concerned about. However, to be a good expert witness, to be able to provide compelling expert evidence, it is important that we look at what is below the waterline, the not-so-visible bits, the underlying practices, procedure, and the law as it pertains to expert evidence. I hope that you enjoy this series of tutes and find them useful. Please don't hesitate to contact us if you have any questions.